Hi, my name is Mark Troutman. I'm a litigation attorney with the law firm of Isaac Brandt, Ledman, and Teeter, and I'm doing a series of video blogs on public records law. Now, many of them have begun in very general terms with advising you how to comply with public records law. This will be one of our more specific blogs involving the confidential law enforcement investigatory record exception, otherwise known as CLEIRS. Now, if we were to do it, we could have an entire series on the CLEIRS exception because, as we'll see, there's very specific requirements that have all been litigated a great deal. So if you have questions whether a specific circumstance meets one of these requirements, we'd certainly ask you and advise you to give us a call or contact your legal counsel. Now, in order to show CLEIRS, you first of all have to have the authority to enforce the law. What this means is that the CLEIRS exception doesn't apply to many of our school district clients, many of our county clients, and other public offices in Ohio. Second, you have to have a specific allegation of misconduct. Next, you have to have conduct that violates the law. This last part means that if you're doing an investigation into potential violations of employment procedures you have at your work, you can't use the CLEIRS exception to protect them from public disclosure. Now, more than those elements, you have to show that disclosing the information would have a high probability of disclosing one of the following 5 types of information. First of all, investigatory work product. This is everything that goes into a law enforcement investigation. We don't want those records being turned over pursuant to a public records request while there's still a pending case. Second, an uncharged suspect. We do not want to release to the public that there's an uncharged suspect when the investigation is still pending. Next, confidential source or witness. Now, if you think about it, this one really makes sense. Why would we want to turn over a confidential source or witness that's actually been promised some level of confidentiality? We would not have that person help us out in subsequent cases, or likely this case. It dovetails very nicely with the next set of circumstances. You should not turn over records when they would endanger the physical safety of someone. Now, the Ohio Supreme Court's been very clear that you need specific threats against you that either serious bodily harm or death could fall upon you or your family. What you can't do is generally say, well, these crazy people are out there and they're going to be mad at me when I do some specific act that I'm required to do because of my official job duties. You need specific allegations of misconduct. Lastly, investigatory techniques and procedures are types of information that you don't have to turn over under the confidential law enforcement investigatory record exception. Hopefully this provides you at least a background on what the CLEIRS exception is under Ohio law. If you have any more questions, please feel free to give me a call. Again, my name is Mark Troutman. My phone number is 614-221-2121. Thank you.